Hello and welcome to SEO Daily. We'll be breaking down day 14 of arguments in the Article 370 hearings today. Senior Advocate Rakesh Dwivedi continued his argument on how the President's power under Article 370 was a constituent power. In the previous hearing, that is day 13, Justice Khanna had said that the only constituent power was the power to frame the Constitution. Today, Dwivedi explained that the constituent power is the power which enables the amendment of the provision of the Constitution. He explained that it is the nature of the power granted to a body that can be defined as constituent, irrespective of the body that it is vested in. Chief Justice D.Y. Chandrachud added to the argument with examples. The court exercises legislative powers by making rules for its function. Parliament exercises judicial power when it initiates contempt proceedings. The chief then summarized Dwivedi's arguments for him, stating that Article 370 was a constituent power because it is a power to amend the application of the Constitution to Jammu and Kashmir. Dwivedi then argued to the respondent's argument that the need for the recommendation of the Jammu and Kashmir Constituent Assembly to abrogate Article 370, that is, was not binding on the President. He took the court through various provisions in the Constitution where the language adopted by the framers left no ambiguity on whether the President could act on his or her own discretion. Dwivedi argued that if they chose to do so, the framers could have made it abundantly clear that the President did not enjoy absolute discretion under Article 370, explicitly binding him to the recommendation of the Constituent Assembly. Next, Dwivedi addressed the petitioner's contention that the source of the powers of Jammu and Kashmir Constituent Assembly and the Jammu and Kashmir Constitution flows from the crown of Maharaja Hari Singh. Almost mockingly, Dwivedi recounted that the petitioners had argued that there was a bilateralism with the Indian and Jammu and Kashmir constitutions, with the two sovereigns talking to each other, whispering at each other and all that. He countered that Article 370 was the source of power over the creation and disappearance of the Jammu and Kashmir Constituent Assembly and Constitution. Further, Dwivedi said, the provision substitutes the Maharaja for the Maharaja acting on the advice of the Council of Ministers, effectively declaring the monarchy dead. This ensured that the people's voice was taken into account and the Maharaja could not act on his own. Dwivedi argued that with the power of the monarch stripped away, he could not have created the Constituent Assembly by himself. Dwivedi then argued that the Jammu and Kashmir Constituent Assembly was bound by the limitations imposed on it by the Constitution of India. First, the Assembly had to ensure that the sovereign Democratic Republic of India was not adversely impacted by the Jammu and Kashmir Constitution. Second, it had to ensure that their constitution enshrined the principles of justice, liberty, equality, and fraternity in line with the Indian counterpart. Third, the Assembly was bound by Article 1 and could not declare that Jammu and Kashmir was not a federal unit of India. Fourth, it could not be said that the permanent residents of Jammu and Kashmir were not citizens of India. This showed that the Jammu and Kashmir Constitution was subordinate to the Indian Constitution. Senior Advocate V. Giri addressed the bench next. Reiterating his colleagues' views, he argued that after the accession, Jammu and Kashmir did not retain any residuary sovereignty. Chronologically, the draft Indian Constitution, which contained Article 370, existed before the Jammu and Kashmir Constituent Assembly came into existence, which was in 1951. Further, Yuvraj Karan Singh, in his proclamation dated 25th November 1949, had declared that the relationship between India and Jammu and Kashmir would be governed by the Indian Constitution. This proclamation, Giri argued, made it clear that J&K was a part of India and was bound by the contours of the Indian Constitution, vesting the state's sovereignty completely with the Union. Next, Giri submitted that the President's power to abrogate Article 370 was absolute. He anchored his argument on the words used in the Article 370. He explained that the need for recommendation sought under Article 373 was from Jammu and Kashmir's Constituent Assembly established under Article 372. Under Article 372, the purpose and function of this Constituent Assembly was limited to the creation of the J&K Constitution. After that constitution was created and the Constituent Assembly dissolved in 1957, the provision had a natural death. The requirement of recommendation under Article 370 also had no significance, and it was coterminous with Article 372. Therefore, he argued, the President's power to abrogate the article did not cease to exist just because the Constituent Assembly ceased to exist. That was a wrap on day 14. Hearings will continue on Monday, that is the 4th of September 2023. Make sure to visit scobserver.in for a detailed report on the day's hearing. Thank you for watching.